federation or by a way of disintegration. A federation can be formed in two ways, that is by way of integration or by way of disintegration. In the first case, a number of militarily weak or economically backward state independent come together to form a federation can be formed in two ways, that is by way of integration or by way of disintegration. In the first case, a number of militarily weak or economically backward state independent come together to form a big and strong union. They come together to form a big and strong union, as for example the US. In the first case, a number of militarily weak or economically backward state that is independent come together to form a big and strong union. As for example, the US. In the second case, a big unitary state is converted into federation by granting autonomy to the provinces to promote regional interests. For example, Canada. A big unitary state is converted into federation by granting autonomy to the provinces to promote regional interests. For example, Canada. The US is the first and the oldest federation in the world. The US is the first and the oldest federation in the world. It was formed in 1787 following the American Revolution 1775 to 1783. The US is the first and the oldest federation in the world. In the case of Canada, the US is the first and oldest federation in the world. It was formed in 1787. It was formed in 1787 following the American Revolution over the 1775 to 1775, 1775 to 83, 1700 and 1775, 1775 to 83. It comprises 50 states, originally 13 states, and is taken as a model federation. Canadian Federation comprising 10 provinces. Originally, it comprises of 10 provinces. Originally, of 4 provinces is also quite old, and it was formed in 1867. And it was formed in 1867. And it was formed in 1867. The Constitution of India provides for the federal system of government in the country. The framers adopted the federal system due to two main reasons: the large size of the country and its socio-cultural diversity. Country and its socio-cultural diversity, they realize that the federal system not only ensures sufficient governance of the country but also reconciles national unity with regional autonomy. However, the term federation has no fair been used in the Constitution. Instead, Article 1 of the Constitution describes India as a union of state. According to Dr. B.R. Ambedkar, the police, however, the term federation has nowhere been used in the Constitution. Term federation has nowhere been used in the Constitution. Instead, Article 1 of the Constitution describes India as a union of state. Instead, Article 1 of the Constitution describes India as a union of state. According to Dr. B.R. Ambedkar, the phrase union of state has been referred to federation of state to indicate two things. The Indian Federation is not the result of an agreement among the states like American Federation. The Indian Federation is not the result of an agreement among the states like the American Federation, and the states have no right to cede from the Federation. The Federation is union because it is indestructible. The Indian federal system is based on the Canadian model. This is important as Indian federal system is based on the Canadian model and not on the American model. The Canadian model differs fundamentally from the American model insofar as it establishes a very strong center. The Indian federalism resembled the Canadian Federation in its formation, uttered by way of disintegration, and in its preference to the term union. The Canadian Federation is also called a union, and in its centralizing tendency and in its centralizing tendency उसको भी यूनियन कहा जाता है, in its centralizing tendency and in its formation that is by way of disintegration. The formation that is by way of disintegration and its formation that is by the way of disintegration and its formation by way of disintegration and its formation that is by and the way of disintegration and its formation that is by way of disintegration and its preference to the term union. The Canadian Federation is also called a union, vesting all powers in the central in comparison to states. Federal features of the Constitution. Federal features of the Constitution. Federal features of the Constitution of India explained below. Dual polity. Federal features of the Constitution. Federal features of the Constitution. Dual polity. The Constitution establishes a dual polity consisting of the union at the center and the state at the periphery. With the central sovereign power to exercise in the field assigned to them respectively by the Constitution, the union government deals with the matter of national importance, like defense, foreign affairs, currency, communication, and so on. The state government on the other hand look after the matter of regional local importance, like public order, agriculture, and local government, and so on. The written constitution. The constitution is not only a written document but also the lengthiest constitution in the world, and it contains a preamble, 395 articles. The union list consists of 100 subjects. The state list consists of 61 subjects, 161, and the concurrent list 52 subjects. Union list 100 subjects, state list 61, concurrent list 52 subjects, concurrent list 52 subjects. स्टेट से कम करते concurrent में डाला करते हैं. Both the center and the states can make laws on the subject of the concurrent list, but in case of conflict, the central law would prevail. The residuary subject, that is, which are not mentioned in any of the state lists, are given to the center, and residuary subjects जो है ये center, which are not mentioned in any of the three lists, which are not mentioned in any of the three lists, which are the and residuary subjects which are not mentioned in any of the three lists are given to the center. Supremacy of the Constitution. The Constitution is the supreme and the highest law of the land. The Constitution is the supreme and the highest law of the land. This law enacted by the center and the state must conform to its provision, otherwise they can be declared invalid by the Supreme Court and the High Court. So their power of judicial review. The Constitution is the supreme and the highest law of the land. The laws enacted by the center and the state must conform to its provision. and secondly more subjects. Center has overriding authority. Center has overriding authority over the current laws when the legislative power also will live with the center, and legislative power also live with the center while it is rested in the state. And as a constitutional very strong states destructible like another federation, the states generally have no right to territorial integrity. The parliament can be unilateral action change the area boundary or name of the state more weight requires only a simple majority. Simple majority, not a special majority. Destructible general, destructible state, indestructible unit. An integrated judicial system with the Supreme Court at the top and the state high court below it. This single system of court enforces both the central laws as well as state laws. Judiciary. Federal government. What is it? On the other hand is one which powers are divided between the national government and the regional government by the constitution itself, and which the powers are divided between the national government and the regional government, the federal government. The federal government is one in which powers are divided between the national government and the regional government, in which powers are divided between the national government and the regional powers are divided between the national government and the regional government. The federal government on the other hand is one in which powers are divided between the national government and the constitutional government. A federal government, on the other hand, is one which powers are divided between the national government and the regional government. National government and the regional government by the constitution itself. The parliament is empowered to legislate matter subject the exclusive arena of state list. The parliament is empowered to legislate on any subject. The parliament is empowered to legislate on any subject of the state list of Rajya Sabha passes a resolution that affects the national interest. The parliament is empowered to legislate on any subject of the state list of Rajya Sabha passes a resolution that affects the national interest. The parliament is empowered to legislate on any subject of the state list of Rajya Sabha passes a resolution to that effect in the national interest. The parliament is empowered to legislate on any subject of the state list. The parliament is empowered to legislate on any subject of the state list of Rajya Sabha passes a resolution to that effect in the national interest. The parliament is empowered to legislate on any subject of the state list, and the parliament is empowered to legislate on a subject mentioned in the state list if Rajya Sabha passes a resolution to that effect in the national interest. The parliament is empowered to legislate on any subject of the state list of Rajya Sabha passes a resolution to that effect in the national interest. This means that the legislative competence of the parliament can be extended without amending the constitution. Notably, this can be done when there is no emergency of any kind. Appointment of government. The governor is at a third state. It is appointed by the president. Also, whether in the pleasure of the president, also act as an agent of the center through him. The center exercises control over the state. The American Constitution, on the contrary, provided for an elected in the state, and this is frequently adopted the Canadian system. Integrated election machinery. The election commission conducts election not only to the central legislature Supreme Court laid down its constitution as federal and characterized federalism as a basic feature. Federalism in the SR Bommai case 1994 in the SR Bommai case in the SR Bommai case, the Supreme Court laid down the constitution as federal and characterized federalism as a basic structure. SR Bommai case 1994 is related to federalism. SR Bommai case SR Bommai case of 1994. SR Bommai case 1994 because of report laid down the constitution is federal and characterized federalism as its basic feature. Supreme Court like the American Constitution, the Indian Constitution established an integrated judicial system with the Supreme Court at the top and the High Court below it, and the High Court and below the state level. There is a hierarchy of subordinate court that is district court and the lower court that is a single system of court adopted from the Government of India Act of 1935 because central laws as well as the state laws in US and other the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. There is a double system of court in USA, one for the central and another one for the state. To sum up, India was a federal country like the USA. The unified judiciary and system of fundamental law and justice. The Supreme Court of India was inaugurated on January 20, 1950. It succeeded the Federal Court of India. It was inaugurated on 28 January 1950. Supreme Court was inaugurated. Supreme Court was inaugurated. India was inaugurated on January 28, 1950. Supreme Court of India was inaugurated. Supreme Court of India was inaugurated on January 28. Supreme Court of India was inaugurated on January 28, 1950. Supreme Court of India was inaugurated on January 28, 1950. The Supreme Court of India was inaugurated on January 28, 1950. Succeeded the Federal Court of India. The Supreme Court of India was inaugurated on 28 January 1950. The Supreme Court of India was inaugurated on 28 January 1950. Succeeded the Federal Court of India. The Supreme Court of India was inaugurated on January 28, 1950. Succeeded the Federal Court of India established under the Government of India Act of 1935. established under the Government of India Act of 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. This is because Article 124 from Article 124 to 147. Article 124 to Article 147 and Part 5 of the Constitution deal with organization, independence, jurisdiction, power, procedure, and so on of the Supreme Court, and it was established on 28 January 1950. 28 January 1950. At present, the Supreme Court consists of 34 judges, 1 Chief Justice, and 33 other judges. Total strength of 34 judges ki 33 plus 1. In 2018, the Centre notified an increase in the number of Supreme Court judges from 31 to 34. Number of judges amendment at 2019. Originally, the strength of the Supreme Court was fixed at 8, 1 Chief Justice, and 7 other judges. The Parliament has increased its number. Originally, the strength was fixed at 8 पे 3, 1 Chief Justice, and 7 others. The Parliament has increased its number of other judges progressively to 10 in 1956 to 13 to 17 to 25 to 30 and to 33 in 2019. But it has 34, that is 33 judges and 1 Chief Justice, 33 judges and 1 Chief Justice. 33 judges and 1 Chief Justice. Appointment of judges. The judges of the Supreme Court are appointed by the President. The judges of the Supreme Court are appointed by the President. Appointed by the judges of the Supreme Court. Appointment of judges. Appointment of judges. Appointment of judges. Appointment of judges. Judges of the Supreme Court are appointed by the President. Judges of the Supreme Court are appointed by the President of India. Chief Justice. The Chief Justice is appointed. The Chief Justice is appointed by the President after consultation with the judges of the Supreme Court and High Court as it deems necessary. The judges are appointed by President of the other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and High Court as it deems necessary. Consultation with the Chief Justice is obligatory in the case other than Chief Justice. The consultation with the Chief Justice is obligatory in the case of appointment of judge other than the Chief Justice. The other judge is appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Court as it may deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than the Chief Justice. Controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the provision. In the first judge's case, that is 1982. In the first judge's case, that is 1982. In the first judge's case, that is in 1982. The court held that consultation is done with concurrence and it only implies exchange of views. In the first judge's case, that is in 1982. In the first judge's case, that is in 1982. The court held that consultation does not mean concurrence and it only implies exchange of views. Controversy over consultation. controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case 1980, the court held that consultation does not mean concurrence and it only implies exchange of views. In the first judge's case, the court held that consultation does not mean concurrence. In the first judge's case, the court held that the consultation does not mean concurrence and it only implies exchange of views. Consultation does not mean concurrence and it only implies exchange of views. The first judge's case 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. But in the second judge's case 1993, the court reversed its earlier ruling, changing the meaning of the word consultation to the concurrence. Hence it ruled that advice taken by the Chief Justice in the first judge's case, the court held that consultation does not mean concurrence. Consultation does not mean concurrence. In the first judge's case, the court held that consultation does not mean concurrence and it only implies exchange of views and it only implies exchange of views. Controversy of a consultation. The Supreme Court has given different interpretation of the word consultation and the other provision. In the first judge's case 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. It upheld that consultation does not mean concurrence and it only implies consultation does not mean concurrence and it consultation does not mean concurrence it only. But in the second judge's case, that is in 1990, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Or it ruled that the advice tendered by the Chief Justice of India is binding on the precedent. Hence it ruled that the advice tendered by the Chief Justice of India advice tendered by the Justice of India is binding on the precedent in the matters of appointment of the judges of the Supreme Court. The Chief Justice would tender his advice on the matter after consulting two of his senior-most colleagues. In the matter of appointment of the Chief Justice would tender his advice on the matter after consulting two of his senior-most colleagues. Similarly, in the third judge's case 1998, 1982, 1993, 1993, the third judge's case 1998, the court opined that the consultation process to be adopted by Chief Justice of India requires Similarly, in the third judge's case 1998, the court opined that the consultation process to be adopted by Chief Justice of India requires consultation of plurality of judges. Third judge's case 1998, the Supreme Court opined that consultation process should to be adopted by a consultation process to be adopted by the Chief Justice of India requires consultation of plurality judges. The sole opinion of Chief Justice of India does not constitute the consultation process. He should consult a collegium of 4 senior judges of the Supreme Court, and even after the judge has given advice opinion, he should not send the recommendation to the government. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirement of the consultation process are not binding on the government. The 99th Constitutional Amendment Act of 2014 and the NJC, that is National Judicial Appointment Commission Act of 2014, have replaced the collegium system of appointing justices of the Supreme Court and High Court with a new body called the National Judicial Appointment Commission. However, in 2015, the Supreme Court has declared both the 99 constitutional amendment as well as the NJC Act is unconstitutional and void. Consequently, the earlier collision system became operative again. The verdict was delivered with the Supreme Court in the four judges case 2015. The court opined as the system and JC would affect the independence of the judiciary. So, controversy or consultation in the first judge's case, it was said that it was opined by the Supreme Court that consultation does not means concurrence and it is just means that expressing of views. In the second judge's case, that is in 1993, it reverted its earlier ruling and it said that consultation means concurrence and the advice tendered by the CJI is binding on the President and the advice tendered by the CJI should be tendered after discussing it with the senior-most two colleagues of the Supreme Court. Advice tendered by the Chief Justice of India is binding on the President in the matter of appointment of the judges of the Supreme Court, but the Chief Justice would tender his advice on the matter after consulting two of his senior-most colleagues. Similarly, in the third judge's case, the court opined that consultation process to be adopted by a plurality of judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. He should consult a collegium of four senior-most judges. This means that he should consult a collegium of four senior-most judges of the Supreme Court, and even if two judges even if two judges have an adverse opinion, even if two judges give an adverse opinion, they should not send recommendation to the government. And even if two judges give an adverse opinion, he should not send the recommendation to the government. The court held that recommendation made by the Chief Justice of India without complying with the norms and requirement of the consultation process and not by the government. Court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. Court held that the recommendation made by the Chief Justice of India without complying with the norms and requirement of consultation process are not binding on the government. Next is this is fourth judge's case in 2015, third judge's case in 1998, 1982, 1993, 1982, 1993 and 1998. Then fourth judge's case came in 2015, appointment of Chief Justice. From 1950 to 1973, the practice has been to appoint a senior-most judge of the Supreme Court as Chief Justice of India. The established convention was violated in 1973 when A&A was appointed as Chief Justice of India by superseding three senior judges. The established convention was violated in 1973. Practice to appoint the senior-most judge violated in 1973 when A.N. Ray was appointed as Chief Justice of India, violated in 1973 when A.N. Ray was appointed as CJI by superseding three senior judges. Again in 1977, M.U. Beg was appointed as Chief Justice of India by superseding the then senior-most judge. A.N. Ray and M.U. Beg, 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 A.N. Ray and M.U. Beg. The discretion of the government was curtailed by the Supreme Court. Was appointed as the Chief Justice of India by superseding the then senior-most judge. This discretion of the government was curtailed by the Supreme Court in the second judge's case, that is in 1993. In the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. In the second judge's case, 1993, Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Senior-most judge of the Supreme Court. In the second judge's case, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. In the second judge's case, 1993, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. In the second judge's case, 1993, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. It is mentioned in the second judge's case. In the second judge's case, it delivered the judgment. In the second judge's case, next is qualification oath and salary. The qualification oath is a person to be appointed as judge of the Supreme Court should have the following qualification. A person to be appointed as a judge of the Supreme Court. A person to be appointed as a judge of the Supreme Court should have the following qualification. He should be a citizen of India. appointed as judge of the Supreme Court, he should have the following qualification. Qualification of and salaries. Qualification of judge is a person to be appointed as judge of the Supreme Court should have the following qualification. Qualification of judge is a person to be appointed as a judge of the Supreme Court should have the following qualification. He should be a citizen of India. What are the qualification of and salaries? Qualification of judge is a person to be appointed as a judge of the Supreme Court should have the following qualification. He should be a citizen of India. He should have been a judge of a high court. Citizen of India, judge of high court or high court in succession for 5 years. Judge of high court, he should have been a judge of high court or high court in succession for 5 years. He should have been a judge. He should have been a judge of high court. He should have been a judge of high court for 5 years, or he should have been an advocate of a high court or high court in succession for 10 years, or he should be a distinguished jurist in the opinion of the president. Or next what is he should be a distinguished jurist in the opinion of the president. He should be a citizen of India. Judge of a high court, he should be a citizen of India. Judge of a qualification of judge, he should have been a judge of a high court for at least 10 years, advocate of high court for 10 years. He should be a citizen of India. He should have been a judge of a high court. He should be a citizen of India. He should have been a judge of a high court or high court in succession for 5 years. He should be a citizen of India. He should be a judge of high court for 5 years, advocate of a high court for 10 years, and distinguished jurist from the work is clear that the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Whether if a petitioner person appointed as a judge of the Supreme Court if entering upon office has to make and subscribe an author petition before the president or some person appointed by him for this purpose and is the judge of the Supreme Court swears to be a true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear of imperfection or ill will, and to uphold the Constitution and the law, salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be varied to the disadvantage after the appointment except during a financial emergency. The salary of the chief justice is increased from 1 lakh to 2.80 lakh per month, and that of a judge from 90,000 to 2.50 lakh per month. They are also paid sumptuary allowance and provided with free accommodation or the other facilities like medical, car, telephone, etc. The retired chief justice and the judges are entitled to 50% of their last one salary as monthly pension, tenure and removal. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. Tenure and removal. Tenure of judges. The Constitution has not fixed the tenure of judge of the Supreme Court. However, it makes the following provision in this regard. He holds office until he attains the age of 65 years. Tenure के लिए नहीं है, but in the Constitution it is mentioned that he holds office until he attains the age of 65 years. He holds office until he attains the age of 65 years. Any question regarding his age to be determined by such authority in such manner as provided by Parliament. He can resign his office by writing to the President. He can resign his office by writing to the President. He can resign his office by writing to the President. The President appoints the judge, and he can resign his office by writing to the President. Resign his office by writing to the President. He can be removed from his office by the President on the recommendation of the Parliament. Removal of judges. A judge of the Supreme Court can be removed from his office by an order of the President. The President can order only after an address to Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority. The address must be supported by a special majority of each house of Parliament. That is, the address must be supported by a special majority of each house of Parliament. That is, majority of the total membership of that house and a majority of 2/3 of member present and voting, and a majority of total membership of that house and a majority of not less than 2/3 of the members of that house present and voting. The ground of removal are to prove misbehavior or incapacity. The Judges Inquiry Act of 1968. The Judges Inquiry Act of 1968 regulates the procedures related to the removal of the Supreme Court with the process of impeachment. The Judges Inquiry Act 1968. The Judges Inquiry Act of 1968. The Judges Inquiry Act of 1968. The Judges Inquiry of 1968. Judges Inquiry Act of 1968 regulates the procedure relating to the removal of the judge of the Supreme Court with the process of impeachment. The Judge Inquiry Act 1968, the Judges Inquiry Act of 1968 regulates the procedure relating to the removal of the judge of the Supreme Court with the process of impeachment. The Judges Inquiry Act of 1968, the Judges Inquiry Act of 1968. The Judges Inquiry Act of 1968 regulates the procedure relating to the removal of a judge of the Supreme Court with the process of impeachment. The Judges Inquiry Act of 1968. The Judges Inquiry Act of 1968 regulates the procedure related to the removal of judge at the Supreme Court by the process of impeachment. The Judges Inquiry Act of 1968 regulates the procedure relating to the removal of a judge at the Supreme Court by the process of impeachment. The Judges Inquiry Act 1968 regulates the procedure relating to the removal of the judge of the Supreme Court by the process of impeachment. Judges Inquiry Act 1968 removal motion signed by 100 members in the case of the Lok Sabha. A removal motion only is signed by 100 members in the case of the Lok Sabha or 50 members in the case of the Rajya Sabha. Removal motion signed by 100 members in case of signed by 100 members in the case of Lok Sabha, 50 members in the case of the Rajya Sabha is to be given to the speaker and chairman. The speaker chairman may admit the motion or refuse it. The speaker or chairman it may admit the motion or refuse it. If it is admitted, then the speaker chairman is to constitute a 3-member committee to investigate into the charges. If it is admitted, then the speaker or chairman is to constitute a 3-member committee to investigate into the charges. The committee should consist of the chief justice or a judge of the Supreme Court. The committee should consist of the chief justice or a judge of a Supreme Court, chief justice or a judge of the Supreme Court, chief justice or judge of the Supreme Court, chief justice. The committee जो है 3-member committee बनेगी और इसके member कौन है? Chief justice या फिर judge of the Supreme Court, chief justice or judge of the Supreme Court, chief justice or judge of the Supreme Court, a chief justice of the Higher Court, and next is a distinguished jurors. So chief justice or judge of Supreme Court and chief justice of Higher Court and a distinguished jury. So the committee finds the judge to be guilty of misbehavior or suffering from incapacity. The House can take up the consideration of the motion after the motion is passed by each of the parliamenters. After the motion is passed by each of the parliament by special majority and addresses presented to the president for the removal of the judge, the president passes an order removing the judge. It is interesting to note that no judge of the Supreme Court has been impeached so far. The first case of impeachment is that of Justice V. Ramaswamy. The first case of impeachment is that of Justice V. Ramaswamy. The first case of impeachment is that of Justice V. Ramaswamy of the Supreme Court. Though the inquiry committee found that I'm guilty, he could not remove as impeachment motion was defeated in the Lok Sabha. The Congress party abstained from voting. Acting ad hoc and retired judges. Appointed judge of the Supreme Court as an acting Chief Justice of India when the office of Chief Justice of India is vacant. The Chief Justice of India is temporarily absent and the Chief Justice of India is unable to perform the duties of his office. So this is acting Chief Justice. Ad hoc judges when there is a lack of quorum of permanent judges to hold a continuous session of the Supreme Court. The Chief Justice of India can appoint a judge of High Court or has an ad hoc judge of the Supreme Court for a temporary period. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of the High Court as an ad hoc judge of the Supreme Court for a temporary period. He can do so only after consultation with the Chief Justice of the High Court, consent with the previous consent of the President. The judge appointed should be qualified for appointment as a judge of the Supreme Court. It is the duty of the judge to appoint to attend the sitting of the Supreme Court in priority to other duties of his office while so attending he enjoys all the jurisdiction powers and privileges and discharges the duties of a judge of the Supreme Court. Justices, when there is a lack of quorum of the permanent judges to hold continuous session of the Supreme Court, the Chief Justice of India can appoint a Chief Justice of India Chief Justice can appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a temporary period. He can do so. He can do so only after consultation with the Chief Justice of the High Court concerned and with the previous consent of the President. Chief Justice can appoint any judge of the High Court as an ad hoc judge of the Supreme Court. He can do so only after consultation with the Chief Justice of the concerned High Court and with the previous consent of the President. The judge appointed should qualify for appointment as a judge of the Supreme Court. It is a duty of the judge appointed to attend the sitting of the Supreme Court entirely to other duties of his office while certain enjoys all the jurisdiction powers and privileges and discharges the duties of the judge of the Supreme Court. A retired judge at any time the Chief Justice of India can request at any time the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court who is duly qualified for appointment as a judge of the Supreme Court to act as a judge of the Supreme Court for a temporary period. At any time the Chief Justice of India can request at any time the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court who is duly qualified for appointment as a judge of the Supreme Court to act as a judge of the Supreme Court. It says that at the end of the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court who is duly qualified for appointment as a judge of the Supreme Court to act as judge of the Supreme Court for a temporary period. He can do so only after with the previous consent of the President and also of the person to be so appointed. Such a judges and titles passes as the President may determine he will also enjoy all the jurisdiction powers and privileges of the judges of the Supreme Court, but he will not otherwise be deemed to be a judge of the Supreme Court. It also authorizes the Chief Justice of India to appoint other places a seat at the Supreme Court, but only with the approval of the President. This provision is only optional and not compulsory. This means that no court can give any direction either to the President or to the Chief Justice to appoint any other place as a seat at the Supreme Court. Procedure of the court. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. The future constitutional bench or it consists of 5 judges. The Supreme Court, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases are references made by the President under Article 143. The constitutional cases are references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. All other single benches and divisional benches all other cases are decided by single judges. The divisional benches, the judgments are delivered by the open court. All judgments are by majority vote, but if different then all judgments are by majority vote, but if different then judges can give dissenting judgments or opinion. Independence of Supreme Court. Independence of Supreme Court has been assigned a very significant role. the salaries, allowances, and pensions of the judges and the staff, as well as the administrative expenses of the Supreme Court, are charged on the CFI. Thus, they are not votable by the Parliament. That they can be discussed by it. Conduct of judges can be discussed. The Constitution cannot be discussed. Sorry, conduct of judges. Conduct of judges cannot be discussed. Conduct of judges. Conduct of judges cannot be discussed. Conduct of judges cannot be discussed. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in state legislature with respect to the conduct of the judges of the Supreme Court and the discharge of the duties, except when impeachment motion is under consideration. The Parliament, by the practice of the retirement, the retired judges of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they don't favor anyone in the hope of future favor. Power to punish for its contempt. The Supreme Court can punish any person for its contempt. Thus its actions and decision cannot be criticized and opposed by any body. The Supreme Court can punish any person for contempt. Thus its action and decision cannot be criticized and opposed by any body. This power is vested in the Supreme Court to maintain its authority, dignity, and honor. Can appoint officers and servants of the Supreme Court with any interference from the executive. We can also prescribe the condition of service. Its jurisdiction cannot be curtailed. The Parliament is not authorized to curtail the jurisdiction and power of the Supreme Court. The Constitution is also guaranteed to the Supreme Court jurisdiction of various kind of the Parliament can extend the same separation from executive. The Constitution directs the state to take steps to separate the judiciary from the executive and the public services. This means that executive authority should not possess the judicial power. Consequently, upon its implementation, original jurisdiction, appellate jurisdiction, advisory jurisdiction, and court of record. Advisory jurisdiction and court of record. We have read in the case of the jurisdiction of the Parliament can empower any other court to issue directions, orders, and writs of all kinds. Original jurisdiction. As a federal court, the Supreme Court decides the dispute between different units of the Indian Federation. More elaborately, any dispute between the center and one or more states, between center and any state or state or center and one or more other states on the other side, and between two or more states stated in the above federal dispute, the Supreme Court has exclusive in the above 2 years of federal disputes in the Supreme Court has exclusive original jurisdiction. Exclusive means no other court can decide such dispute, and original means the power to hear such dispute in the first instance, not by way of appeal. Original, and the power to hear such dispute in the first instance, not by way of appeal. Not by way of appeal, not necessarily by way of appeal. Not necessarily by way of appeal. Not necessarily by way of appeal. So in the above federal dispute, the Supreme Court has exclusive original jurisdiction. Exclusive means no other court can decide such dispute. Exclusive means no other court can decide such dispute, and original means the power to hear such dispute in the first instance, not by way of appeal. With regard to the exclusive original jurisdiction of the Supreme Court, a point should be noted when the dispute must involve a question whether of law or fact or which the existence or extent of legal right depends. Thus, the question of political nature is excluded from it. Thus, two, any suit brought before the Supreme Court by a private citizen against the center or a state cannot be entertained under this. Two, any suit brought before the Supreme Court by a private citizen against the center or the state cannot be entertained by it. Second, any suit brought before the Supreme Court by a private citizen against the center or state cannot be entertained by this. Any suit brought before the Supreme Court by a private citizen against the center or a state cannot be entertained under it. Further, this section of the Supreme Court does not extend to the following. It does not extend to the following: a dispute arising out of any pre-constitutional treaty agreement, covenant engagement, sanad, or other similar instrument. A dispute arising out of any treaty agreement, etc., which specifically provided the state jurisdiction does not extend to such a dispute. Interstate water dispute does not extend to the following. Interstate water dispute किसी में आता है ओरिजिनल में interstate water dispute हो गया और क्या हो गया matters referred to the finance commission does not extend adjustment of certain expenses and binding between the center and state. Ordinary dispute of commercial issue between the center and the state. Recovery of damages by the state against the center. In 1961, the first suit under the original jurisdiction of the Supreme Court was brought by West Bengal against the center. The state government challenged the constitutional validity of the Coal Bearing Areas Acquisition and Development Act of 1957 passed by the Parliament of the Supreme Court dismissed the suit by upholding the validity of the jurisdiction. The Constitution has constituted the Supreme Court as a guarantor and defender of the fundamental right of the state. The Supreme Court is empowered to issue writ including habeas corpus mandamus prohibition quo warranto and certiorari for the enforcement of the fundamental right of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Original and exclusive. Original that it can go directly to the Supreme Court without making appeal. Next is, however, the jurisdiction of the Supreme Court is not exclusive. The High Court are also empowered to issue it on the enforcement of the FR. It means on the fundamental right of a citizen and violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Therefore, the original jurisdiction of the Supreme Court with regard to federal dispute is different from its original jurisdiction with regard to dispute related to what FR. In the first case, it is exclusive, and in the second case, moreover, the parties involved in the first case are unit of federation, while dispute in the second case is between citizen and the government. Therefore, the original jurisdiction of the Supreme Court with regard to federal dispute is different from its original jurisdiction with regard to dispute relating to the FR. Okay, there is also a difference between the jurisdiction of the Supreme Court and that of the High Court. The Supreme Court can issue it only for the enforcement of the FR and not for the purpose of the High Court, and the other hand can issue it only for the enforcement of FR but also for other purpose. It means that the jurisdiction of the High Court is wider than that of the Supreme Court, but the Parliament can confer the Supreme Court the power to issue writs for other purpose also. But the Parliament can confer the Supreme Court the power to issue writs for other purposes also. For the other purposes also, the Parliament can confer on the Supreme Court the power to issue writs for other purposes also. Next comes the appellate jurisdiction. As mentioned earlier, the Supreme Court has not only succeeded the Federal Court of India but also replaced the British Privy Council as the highest court of appeal. The Supreme Court is primarily a court of appeal, and here appeals against the judgment of the lower court. It enjoys a wide appellate jurisdiction. It enjoys a wide appellate jurisdiction which can be classified under the four head appeals and constitutional matter appeals in civil matters, appeals in criminal cases, and appeals by special leave. In the constitutional case, an appeal can be made to the Supreme Court against the judgment of High Court if the High Court certifies that the case involves a substantial question of law that requires the interpretation of the Constitution. Based on the certificate, the party in the case can appeal to the Supreme Court on the ground that the question has been wrongly decided. Civil matters and civil cases, an appeal lies to the Supreme Court from any judgment of High Court if the High Court certifies. In civil cases, an appeal lies to the Supreme Court for any civil matters. In several cases, an appeal to the Supreme Court. An appeal lies to the Supreme Court from any judgment of High Court if the High Court certifies that the case involves a substantial question of law of general importance and that the question needs to be decided by the Supreme Court. Next is originally only those several cases that involved a sum of 20,000 would be appealed before the Supreme Court, but this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. Originally, only those civil cases. Originally, only those civil cases that involve sum of 20,000 could be appealed before the Supreme Court. But the monetary limit was removed by the 30th Constitutional Amendment Act of 1972. Originally, only those civil cases that sum of 20,000 could be appealed before the Supreme Court. Originally, only those civil cases that involved a sum of ₹20,000 could only be appealed before the Supreme Court, but this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. But this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. 30th Amendment Act of 1972. Originally, only those civil cases involved a sum of 20,000 could be appealed before the Supreme Court, but this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. 1972. Criminal matters. The Supreme Court hears appeal against judgment in the criminal proceeding of a higher court if the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death. As an appeal reverses an order of acquittal of an accused person and sentenced him to death, or has taken for itself any case from any subordinate court and convicted the accused person and sentenced him to death, and certifies that the case is fit one for appeal to the Supreme Court. Certifies that the case is a fit one for appeal to the Supreme Court. Fit one for the appeal to the Supreme Court. For the appeal to the Supreme Court. In the first two cases, an appeal lies to the Supreme Court as a matter of right. Certifies that the case is fit one appeal to the Supreme Court. In the first two cases, an appeal lies to the Supreme Court as a matter of right, that is without any certificate of the High Court. Has an appeal reversed an order of acquittal of an accused person and sentenced him to death, and has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to death. In Supreme Court as a matter. In the first two cases, an appeal lies to the Supreme Court as well as matter of right. In the first two cases, an appeal lies to the Supreme Court as a matter of right, that is without any certification of the High Court. That is in the case of the sentenced him to death, and court should be taken. मतलब High Court take the subordinate court case and convict the accused person and sentence him to death. But if the High Court has reversed the order of conviction and has ordered the acquittal of the accused, there is no right to appeal against the Supreme Court. But if the High Court has reversed the order of conviction and has ordered the acquittal of the accused, there is no right to appeal to the Supreme Court. In 1970, the Parliament had enlarged the criminal appellate jurisdiction of the Supreme Court. According to an appeal lies with the Supreme Court from the judgment of a High Court if the High Court has an appeal receipt. In 1970, the Parliament enlarged the criminal appellate jurisdiction of the Supreme Court. Accordingly, an appeal lodged at the Supreme Court from the judgment of the High Court in the High Court. एनलार्ज कर दिया था द क्रिमिनल अपीलेट जुरिस्डिक्शन ऑफ द सुप्रीम कोर्ट. इसमें an appeal lodged at the Supreme Court on the judgment of the High Court if the High Court has an appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or for 10 years. Has an appeal अगर क्या किया है an appeal lies to the Supreme Court from the judgment of the High Court if High Court has an appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or for 10 years or has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to imprisonment for life or for 10 years. Further, the appellate jurisdiction of the Supreme Court extends to all civil and criminal cases in which the Federal Court of India had jurisdiction to hear appeals from the High Court but which are not conferred under the civil and criminal appellate jurisdiction of the Supreme Court mentioned above. Further, the appellate jurisdiction of the Supreme Court extends to all civil and criminal cases in which the Federal Court of India had jurisdiction to hear appeals from the High Court but which are not covered in the civil and criminal appellate jurisdiction of the Supreme Court mentioned above. The appellate jurisdiction of the Supreme Court extends to all civil and criminal cases in which the Federal Court of India had jurisdiction to hear appeals from High Court but which are not covered in the civil and criminal appellate jurisdiction of the Supreme Court mentioned above. Appeal by special leave. The Supreme Court is authorized to grant in its discretion. Appeal by special leave. The Supreme Court is authorized to grant in its discretion. Special leave. कॉन्स्टिट्यूशन मैटर्स सिविल मैटर्स 20,000 के ऊपर का केस होगा और ये लिमिट हटा दी गई थी बाय 13th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट ऑफ 1972. तो ये सुप्रीम कोर्ट में जाता है. appeal constitutional matters, civil matters, criminal matters, and appeals by special leave. अगर हाई कोर्ट वाली सुप्रीम कोर्ट में तब जाएगी जब हाई कोर्ट का जो ऑर्डर होगा सबऑर्डिनेट कोर्ट से उसने ट्रांसफ़र किया होगा और उसने डेथ सेंटेंस ऑफ लाइफ इम्प्रिजनमेंट दे दिया होगा. सेंटेंस टू डेथ एंड लाइफ इम्प्रिजनमेंट. Advisory jurisdiction. The Constitution Article 143 authorizes the President to seek the opinion of the Supreme Court in two categories of matter. The Constitution Article 143 authorizes the President to seek the opinion of the Supreme Court in the two categories of matter on any question of law or fact of public importance which has arisen or which is likely to arise on any dispute arising out of free constitutional treaty agreement, covenant engagements, and or similar instrument. In the first case, the Supreme Court to tender his opinion to the President on any question of law or a fact of public importance which has arisen or which is likely to arise, on any question of law or fact of public importance which has arisen or which is likely to arise, on any question of law or a fact of public importance which has arisen or which is likely to arise. But in the second case, the Supreme Court must tender its opinion to the President. But in the second case, the Supreme Court must tender its opinion to the President. In both the cases, the opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement, hence it is not binding on the President. It may follow or may not follow the opinion, however, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. So far, 2019, the President has made 15 references to the Supreme Court under its advisory jurisdiction, also known as consultative jurisdiction. These are mentioned below. the Law Act, Kerala Education Bill, Virwar Union 3 Customs cases in case related to the privileges of the legislature, presidential election, special court bill, Jammu Kashmir, Resettlement Act, Kaveri water dispute, Ram Janmabhoomi consultation process to be adopted by the CJI. Third Judges Case 1998 जिसमें 4 senior most judges का साथ करना था. Next is consultation process to be adopted by Chief Justice of India. Legislative competence of the center and the state on the subject of natural gas and liquefied natural gas. The constitutional validity of ECA's decision defining the Gujarat Assembly election. Punjab termination of agreement. Act spectrum case for mandatory auctioning of natural resources across all sectors in 2012. Next is, as a court of record, the Supreme Court has to pass the judgment proceeding and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedent, legal references. It has power to punish for contempt of court, either with simple imprisonment or a term up to 6 months, or with a fine of either with simple imprisonment for a term up to 6 months, or with a fine up to 2,000, or with both. In 1991, Supreme Court has ruled that it has the power to punish for contempt not only of itself but also of high court, subordinate court, and tribunal functioning in the entire country. Contempt of court may be civil or criminal. Civil contempt means willful disobedience to any judgment, order, or other process of court, or willful breach of an undertaking given to the court. Criminal contempt means with the application of punishment or doing any act which scandalizes the laws or authority of a court, prejudices or interferes with the allowed course of a judicial proceeding, interferes or obstructs the administration of justice in any country. However, innocent public and distribution of some matter, fair and accurate report of judicial proceeding, fair and reasonable criticism of judicial acts and comment on the administrations of the judicial contempt of court. However, innocent publication and distribution of some matter, fair and accurate report of judicial proceeding, fair and reasonable criticism of judicial action, comment on the administrative side of the judiciary do not amount to contempt of court. Power of judicial review. Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactment and executive order for the central and state government. On examination, if they are found to be violative of the Constitution, they can be declared as illegal, unconstitutional, and invalid by the Supreme Court. Consequently, they cannot be enforced by the government. Constitutional interpretation. The Supreme Court is the ultimate interpreter of the Constitution. It can give validation to the spirit and content of the provision of the Constitution and the verbiage used in the Constitution. While interpreting the Constitution, the Supreme Court is guided by a number of doctrines, of which the Supreme Court applies various doctrines in interpreting the Constitution. The important doctrines are doctrine of severability, where eclipse, state or nexus, pension, substance, collegible legislation, implied powers, incidental and ancillary powers, precedent, prospect of overruling, harmonious construction, liberal interpretation of the power. Besides the Supreme Court has numerous other power. It decides a dispute regarding the election of vice president in the second. It has original, exclusive, and final authority. Original, that is, we can directly approach to the Supreme Court without by any effect. And in the second, it has original, exclusive, and final authority to consider the conduct and behavior of the chairman and member of the UPSC. On a reference made with the president, if it finds them guilty of severity, it can recommend to the president. The advice tendered to the Supreme Court in the second is binding on the president. अगर इस केस में होगा it is to for removing the chairman and members of the UPSC, then this advice is binding on the president. It has the power to review its own judgment or order. It has the power to review its own judgment or order. Unless it is not bound by its previous decision, and apart from it, in the interest of justice, the community will be enraged. The Supreme Court is self-correcting agency from, for example, in the case of the Bharati case, the Supreme Court departed from its previous judgment in the Goldakhnath case. It is authorized to withdraw the cases pending before the High Court, and it is authorized to withdraw the cases pending before the High Court and dispose them by itself. It can also transfer a case or appeal pending before one High Court or another High Court. Its law is binding on in India. Its decree or order is enforceable throughout the country. Its decree or order is enforceable throughout the country. All authorities, civil and judicial in the country should act in 8 of the Supreme Court, it has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. The Supreme Court's jurisdiction and powers with respect to matters in the Union list can be enlarged by the Parliament. The Supreme Court's jurisdiction and powers with respect to matters in the Union list can be enlarged with the Parliament. The Supreme Court's jurisdiction and powers with respect to the matters in the Union list. Further, jurisdiction and powers with respect to the matter can be enlarged by special agreement of the Centre and the State Supreme Court advocate. C categories of advocates are entitled to practice law before the Supreme Court. They are senior advocate. एक हो गया senior advocate, second is advocate on record, and third is other advocates. These are advocate or designated as senior advocate by the Supreme Court of India or by any high court. The court can designate any advocate with his consent as senior advocate if, in its opinion, by virtue of his ability, standing at the bar, or special knowledge or experience in law, the said advocate is deserving of such distinction. These advocates were designated as senior advocate by the Supreme Court of India or by any high court. The court can designate any advocate with his consent or senior advocate if, in its opinion, by virtue of his ability, the said advocate is deserving of such distinction. Senior advocate is not entitled to appear without an advocate or record in the Supreme Court or without a junior in any other court or tribunal in India. He is also not entitled to accept instruction to draw pleading or affidavit advice or an evidence, advise on evidence, or do any drafting work of an analogous kind in any court or tribunal in India, or undertake conveyancing work of any kind whatsoever. But this provision shall not extend to settling any such matter as aforesaid in consultation with the union. Advocates in the court, only these advocates are entitled to file any matter of document before the Supreme Court. Advocates on record कौन होते हैं? These advocate are entitled to file any matter on document before the Supreme Court. They can also file the appearance or act of a party in the Supreme Court. Other advocate, these advocate whose names are entered out in the roll of any state by council maintained under the Advocate Act 1961, and they can appear and argue any matter on behalf of a party in the Supreme Court, but they are not entitled to file any document or matter before the court. They are entitled to, but they are not entitled to file any document or matter before the court. Only advocates on record. Only these advocates are entitled to file any matter or document before the Supreme Court. Only these advocates. Only these advocates. Status advocate on record. Only these advocates are entitled to file any matter or document before the Supreme Court. They can also file an appearance or act of party in the Supreme Court. Comparative Indian American Supreme Court. Its original jurisdiction is confined to federal cases. Its original jurisdiction covers not only federal cases but also cases relating to naval forces, military authority, ambassadors, etc. Its appellate jurisdiction covers constitutional, civil, and criminal cases. Okay, it has a very wide discretion to grant special leave to appeal by any matter against the judgment of any court or tribunal except military. Special leave. If the court allows that, it requires such a question of law. It wants to answer a substantial question of law which cannot be answered by the High Court, and it can only be answered by the Supreme Court. It requires an interpretation of the Constitution. It has a very wide discretion to grant special leave to appeal in any matter. It has a very wide discretion to grant special leave to appeal in any matter. It has no such plenary powers such as the special leave to grant special leave to appeal. What is its name? Appeal by special leave. It has advisory jurisdiction. It has no advisory jurisdiction. According to the procedure established by law, which is taken by the Japanese Constitution, it defines right of the citizen according to the due process of law. Its jurisdiction and powers can be enlarged with the Parliament by the Constitution and limited to that conferred by the Constitution. It has power of judicial superintendence, control over state, high court, which is related to judicial system. It has no such power due to double or separated judicial system. Double separated judicial system 121. 141 law declared the Supreme Court to be binding on all courts. Law decided by the law declared by the Supreme Court. Law declared by the Supreme Court to be binding on all the courts. Law declared by the Supreme Court to be binding on all the court. Law declared by the Supreme Court to be binding on all court. Law declared by the Supreme Court to be binding on all court. Law declared by the Supreme Court to be binding on all the courts. Enforcement of decrees and order of the Supreme Court and order as to discovery. Law declared by the Supreme Court to be binding on all the courts. In the Indian single integrated judicial system, the High Court operates below the Supreme Court. In the Indian integrated judicial system, in the Indian single integrated judicial system, the High Court operates below the Supreme Court, but is subordinate to the judiciary. In a state consists of a High Court and a hierarchy of subordinate court. The judiciary in a state consists of a High Court and a hierarchy of subordinate court. The High Court occupies its opposition. The judicial administration of a state. The institution of High Court originated in India in 1862 when the High Court was set up at Calcutta, Bombay and Madras. It was started in 1862. The institution of High Court originated in India in 1862. The institution of High Court. The institution of High Court originated in India in 1862 when the High Court was set up at Calcutta, Bombay, Madras. In 1868, the fourth High Court was established at Allahabad. In 1862, three courts were established at Calcutta, Bombay, and Madras. Calcutta, Bombay, and Madras. The fourth High Court was established at Allahabad. In the course of time, each province and protection came to have its own High Court. After 1950, High Court existing in a province became the High Court for the corresponding state. The Constitution only provides for a High Court for each state, but the 7th Amendment Act of 1956 authorized the Parliament to establish a common High Court for two or more states. But the 7th Amendment Act of 1956 authorized the Parliament to establish a common High Court for two or more states, and a union territory. The territorial jurisdiction of a High Court is coterminous with the territory of a state. Similarly, the territorial jurisdiction of a common High Court is coterminous with the territories of the concerned state and the UTs. At present, 2019, there are 25 High Courts in the country. Out of them, only 3 High Courts have jurisdiction over more than one state. Among the 9 UTs, Delhi alone has a separate High Court. Among the 9 UTs, Delhi alone has a separate High Court. There are total 25 High Courts in the country. Out of them, only 3 High Courts have jurisdiction over more than one state. Only 3 High Court have jurisdiction over more than one state, and among the 9 UTs, Delhi alone has a separate High Court. Since 1966, the UT of Jammu and Kashmir and Ladakh have a common High Court. The other UTs fall under the jurisdiction of different state High Court. The Parliament can extend the jurisdiction of a High Court to any UT or exclude the jurisdiction of a High Court from any UT. The name, year of establishment, title, and jurisdiction of the seat with benches of all the 25 High Court are mentioned in table 34 in 1 at the end of the chapter. Article 214 to Article 231 and 124 to 147, 214 से लेकर के to 231. Article 214 to 231. Article 200 and Article 214 to 214, Article 214 to Article 231, Article 214 to 231, Part 6 of the Constitution. And it is mentioned in Part 6 of the Constitution. And it is mentioned in Part 6 of the Constitution. And it is mentioned in Part 6 of the Constitution, Article 214 to 231, and Part 6 of the Constitution deal with the organization, independence, jurisdiction, power, procedures of the High Court. Composition and appointment of the High Court with the exclusive or common consist of a Chief Justice and such other judges of the President may from time to time deem necessary to appoint. Thus, the Constitution does not specify the strength of a High Court and leaves it to discretion of the President. Thus, the Constitution does not specify the strength of a High Court. Constitution does not specify the strength of a High Court and leaves it to the discretion of the President Accordingly, the President determines the strength of High Court from time to time depending upon its own appointment of judges. The judges of High Court are appointed by the President. The judges of High Court are appointed by the President. Judges of the High Court, like the Supreme Court, are appointed by the President. Judges of High Court are appointed by the President. The Chief Justice is appointed by President after consultation with the Chief Justice of India and the Governor of the concerned state. The Chief Justice is appointed by the President after consultation with the Chief Justice of India and the Governor of that concerned state for appointment. For the judges, the Chief Justice of the concerned High Court is also consulted in case of a common High Court. For 2 or more states, the governors of all the states consulted by the President. In case of a common High Court, for 2 or more states, the governor of the state consulted after the governors of the concerned state are consulted with the President. In the second judge's case 1993, in which the court has reversed its earlier judgment and said that consultation means concurrence, and the advice tendered by CJI is to be backed by 2 senior most colleagues. And the advice of the CJI is necessary. So in the second judge's case 1993, the Supreme Court ruled that no appointment of a judge of the High Court can be made unless it is in conformity with the opinion of the Chief Justice of India. No appointment of a judge of the High Court can be made unless it is in conformity with the opinion of the Chief Justice of India. Next is the third judge's case 1998, the Supreme Court opined that in case of the appointment of the High Court judges, the Chief Justice of India should consult a collegium of 2 senior judges of the Supreme Court. The sole opinion of the Chief Justice of India alone does not constitute the consultation process. इसमें बोला गया था कि in the second judge's case it was mentioned that in the second judge's case it was mentioned that in the second judge's case ruled that no appointment of a judge of the High Court can be made unless it is in conformity with the opinion of the Chief Justice of India. In the second judge's case में बोला था कि no appointment of a judge of the High Court can be made unless it is in conformity with the opinion of the Chief Justice of India. No appointment of a judge of the High Court can be made unless it is in conformity with the opinion of the Chief Justice of India. And in the third judge's case 1998 में the Supreme Court opined that appointment of High Court judges in case of the appointment of the High Court judges, the Chief Justice of India should consult a collegium of 2 senior most judges of the Supreme Court. In case of appointment of High Court judge, the Chief Justice of India should consult a collegium of 2 senior most judges of the Supreme Court. This is the sole opinion of the Chief Justice of India. It does not alone constitute the constitutional process. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointment Commission Act 2014 have replaced the collegium system of appointing judges of the Supreme Court and High Court with a new body called NJAC, that is National Judicial Appointment Commission. However, in 2013, the Supreme Court has declared both the 19th Constitutional Amendment as well as the NJAC Act as unconstitutional and void. Consequently, the early collegium system became operative again. The verdict was delivered with the Supreme Court in the fourth judge's case. The court opined that the new system, that is NJAC, would affect the independence of the judiciary. Qualification oath and salaries. Qualification of judges: a person to be appointed as a judge of a High Court should have the following: he should be a citizen of India, should have held a judicial office in the territory of India for 10 years. He should have held a judicial office in the territory of India for 10 years. He should have judicial office. He should have held a judicial office in the territory of India. Held a judicial office in the territory of India for 10 years. He should have held a judicial office in the territory of India for 10 years. He should have been an advocate. He should have been an advocate of a High Court. High Court for 10 years. He should have been an advocate of a High Court or High Court and succession for 10 years. एक तो एडवोकेट हो गया, 10 साल के लिए होना चाहिए. And held a judicial office. He should have held a judicial office. He should have held a judicial office in the territory of India for 10 years. He should have held office. He should have held a judicial office in the territory of India for 10 years. He should have held office. He should have held a judicial office in the territory of India for 10 years. He should have held a judicial office in the territory of India for 10 years. He should have been an advocate of High Court or High Court in succession for 10 years. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of High Court, more unlike in the case of the Supreme Court. The Constitution makes no provision for appointing of a distinguished juris as a judge of High Court. Author of information person appointed as judge of a High Court for entering upon his office has to make and subscribe an oath or information for the governor of the state or some person appointed by him for the purpose in his oath or judge of a High Court swears to be a true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear of favor, affection or ill will, and to uphold the Constitution and laws. Services, salaries and allowances, privileges, leave and pension of the judges of High Court are determined from time to time by the Parliament. These are determined by the Parliament. They cannot be varied to the disadvantage of the appointment exceeding financial emergency. 2018, the salary of the chief justice is increased from 9,000 to 2.50 lakh per month and that of the judge from 80,000 to 2.25 lakh per month. They are also with some jury allowance and provided with free accommodation and other facilities like medical card, telephone, etc. The retired chief justice and judges are entitled to 50% of the large on salary as monthly pension, tenure removal and transfer. Tenure of judges. The Constitution has not fixed the tenure of the judges of the High Court. However, it makes the following for provision in this regard. Has not fixed the Constitution has not fixed the tenure of a judge. However, it has four provisions in this regard. It holds office until he holds office until he attains the age of 62 years, and in the case of Supreme Court it is 65 years. It was added by the 15th Constitution Amendment of 1963. Aged from 60 to 62 years by the 15th Amendment Act of 1963. 15th Constitutional Amendment Act of 1963 जो एज है उसको रेज कर दिया था from 60 to 62 years. Any question regarding his age to be decided by the President after consultation with the Chief Justice of India, and the decision of the President is final. He can resign his office by writing to the President. He can be removed from his office by the President on the recommendation of the Parliament. He vacates his office when he is appointed as a judge of the Supreme Court or when he is transferred to another High Court. Removal of judges. A judge of High Court can be removed from his office by an order of the President. The President can issue the removal order only after an address of the Parliament is presented to him in the same session. First removal. The address must be supported by a special majority of each house of Parliament, that is the majority of the total membership of that house and the majority of the 2/3 of people present and voting at that time. On the grounds of removal or that is proof means favor or incapacity, thus a judge of a High Court can be removed in the same manner and on the same ground as a judge of the Supreme Court. Judge of a High Court can be removed in the same manner. Judge of a High Court can be removed in the same manner and on the same ground as judge of the Supreme Court. The Judges Inquiry Act of 1968 regulates the procedure relating to the removal of a judge of High Court by the process of impeachment. The removal motion signed by 100 members in the case of Lok Sabha or 15 members in the case of Rajya Sabha, and it must be submitted to the Speaker or the Chairman in the case of the Speaker in the case of the Lok Sabha. The Speaker Chairman may admit the motion or refuse to admit it. If it is admitted, then the Speaker or Chairman is to constitute a 3-member committee to investigate into the charges. और 3-member committee में सबसे पहले जो होंगे that is the Supreme Court के judge, Chief Justice of High Court, and the third person is a distinguished jurist. First is Chief Justice of Supreme Court, Chief Justice or Judge for Supreme Court, Chief Justice of High Court, and distinguished jurist. When the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. After the motion is filed by each of the Parliament by special majority, and address is presented to the President for removal of the judge. Finally, the President passes an order removing the judge. Next is, from the above, it is clear that the procedure for the appointment of a judge of High Court is the same procedure for the judge of the Supreme Court. It is interesting to know that no judge of the High Court has been impeached so far. Transfer of judges, the President can transfer a judge from one High Court to another after consulting the Chief Justice of India. Who will transfer? That is the President. Obviously, the President will transfer. President can transfer a judge from one High Court to another after consulting the Chief Justice of India. Or transfer is entitled to receive an addition to his salary such compensatory allowance as may be determined by Parliament. in 1977, the Supreme Court ruled that transfer of High Court judges could be resorted to only as an exceptional measure and only in public interest and not by way of punishment. Again, in 1995, the Supreme Court held that judicial review is necessary to check arbitrariness in transfer of judges, but only the judge who is transferred can challenge it. In the third judges case, the Supreme Court opined that in case of the transfer of High Court judges, the Chief Justice of India should consult, in addition to the collegium of 4 senior justices of the Supreme Court, the Chief Justice of the 2 High Court, from basic judges being transferred and the other receiving CJ plus 4 judges of the Supreme Court, that is the senior judges of the Supreme Court, plus Chief Justice of 2 High Court and Chief Justice of the 2 High Court, one from which the judges being transferred and the other receiving him. तो 2 चीफ जस्टिस लगेंगे, एक जहाँ से वो जज को उठा करके दूसरी जगह डाला जाएगा और एक दूसरा वहाँ का. So in the third judges case 1998, in the third judges case 1998, the Supreme Court opined that in case of the Supreme Court opined that in the case of the transfer of High Court judges, the Chief Justice of India should consult, in addition to the collegium of 4 senior most judges. This is important कि 4 senior most judges को देखेगा, CJ plus 4 senior most judges of the Supreme Court, the Chief Justice of 2 High Court, one from which the judge is being transferred and the other receiving. Thus, the sole opinion of the Chief Justice of India does not constitute the consultative process. Acting additional and retired judges. Acting मतलब the president can appoint a judge of a High Court as an acting Chief Justice of the High Court, as can appoint a judge of High Court as an acting Chief Justice of the High Court when the office of the Chief Justice of the High Court is vacant and the Chief Justice of the High Court is temporarily absent and the Chief Justice of the High Court is unable to perform the duties of his office. Additional and acting judges. The president can appoint duly qualified person as additional judges of High Court for a temporary period not exceeding 2 years. Additional and acting judges. The president can appoint duly qualified person as additional judges for a temporary period not exceeding 2 years. There is temporary increase in the business of the High Court and there are years of work in the High Court. The president can also appoint a duly qualified person as an acting judge of a High Court when the judge of that High Court, other than Chief Justice, is unable to perform the duties of his office due to absence or any other reason, appointed to act temporarily as Chief Justice of that High Court and an acting judge holds office until the permanent judge assumes his office. However, both additional and acting judge cannot hold office after attaining the age of 62 years. Retired judges. At any time, the Chief Justice of a High Court. In the case of the retired judges, the Chief Justice of High Court of a state can request a retired judge of that High Court or any other court to act as a judge of the High Court of that state for a temporary period. He can do so only with the previous consent of the president, also of the person to be appointed. At any time, the Chief Justice of High Court only एक state can request the retired judge of the High Court or any other court to act as a judge of the High Court. The Chief Justice of a High Court of a state can request a retired judge of that High Court or any other High Court to act as judge of the High Court of that state for a temporary period only with the previous consent of the president and also of the person to be appointed as a judge is entitled to such allowances as the president may determine. He will also enjoy all the jurisdiction powers and privileges of a judge of that High Court, but he will not otherwise be deemed to be judge of that High Court. Independence of High Court. The independence of High Court is really essential for the effective discharge of the duties assigned to it. It should be free from the enforcement pressure and interferences with the executive, council, and the legislature. It should be allowed to do justice without fear of favor. The Constitution has made the following provision to safeguard and to ensure the independent and impartial functioning of the High Court. Pehla mode of appointment the judges of a High Court are appointed by the president, which means the cabinet in consultation with the members of the judiciary itself, that is Chief Justice of India and the Chief Justice of the High Court. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointment are not based on any political or practical consideration. Security of tenure. The judges of High Court are provided with the security of tenure. They can be removed from office by the president only in the manner and the ground mentioned in the Constitution. This means that they do not hold their office during the pleasure of the president, though they are appointed by him. This is obvious from the fact that no judge of High Court has far been removed and imposed so far. Fixed service conditions, salaries, allowances, privileges, leave and pension of judges of a High Court are determined from time to time by the Parliament, but they cannot be changed to the disadvantage after their appointment except during a financial emergency. That's a condition of service of the judges of High Court remain same during their term of office. Expenses charged on CFI. जो pension of the High Court होती है, pension of the High Court, it should be noted here that the pension of High Court judge is charged on the consolidated fund of state and not the state. The pension of High Court judges, the pension of the High Court judges is charged on the consolidated fund of India and not the state. The pension of High Court judge is charged on the consolidated fund of India and not the state. It should be noted here that the pension of High Court judge is charged on the consolidated fund of India and not the state. It should be noted here that pension of a High Court judge is charged on the consolidated fund of India and not the concerned state. Conduct of judges cannot place the Constitution prohibits any discussion in Parliament or in state legislature with respect to the conduct of the judges of a High Court in the discharge of duties, except when an impeachment motion is under consideration of the Parliament. Ban on practice after retirement. The retired permanent judges of a High Court are prohibited from leading or acting in any court or before any authority in Indian context. The retired or permanent judge of a High Court, the retired permanent judges of a High Court are prohibited from pleading or acting in any court or before any authority in India except the Supreme Court and the High Court. This ensures that do not favor anyone in the hope of future favor power to punish for its contempt of court. The High Court can punish any person for its contempt, thus its action and decision cannot be criticized and opposed by anybody. This power is vested in the High Court to maintain its authority, dignity and honor, freedom to appoint and staff the Chief Justice of High Court and appoint officers of the office of the High Court without any interference from the executive and can also prescribe the condition of service. Its jurisdiction cannot be curtailed. The jurisdiction and power of the High Court, in so far as they are specified in the Constitution, cannot be curtailed both by the Parliament and the state legislature. But in other aspects, the jurisdiction and powers of the High Court that can be changed both by the Parliament and the state legislature. Its jurisdiction cannot be curtailed. The jurisdiction and powers of the High Court in the Constitution cannot be curtailed both with the Parliament and the state legislature, but in other jurisdiction powers of High Court can be changed both with the Parliament and the state legislature. Separation from executive. On the Constitution directs the state to keep take steps to separate the judiciary from executive and public service. This means that the executive authority should not pass its judicial powers. Consequent upon this implementation, the role of executive authorities in judicial administration came to an end. Jurisdiction and powers of the High Court. Jurisdiction and powers of the High Court. Jurisdictions and powers of the High Court. गुवाहाटी हाई कोर्ट असम नागालैंड मिजोरम अरुणाचल प्रदेश. असम भी आता है, नागालैंड मिजोरम एंड अरुणाचल प्रदेश. असम नागालैंड मिजोरम एंड अरुणाचल प्रदेश. वेस्ट बंगाल अंडमान निकोबार आइलैंड कैलकाटा जुरिस्डिक्शन. बॉम्बे महाराष्ट्र बहुत ज़्यादा. नागर हवेली दमन एंड दीव. असम नागालैंड मिजोरम अरुणाचल प्रदेश. असम नागालैंड मिजोरम अरुणाचल प्रदेश. असम नागालैंड मिजोरम अरुणाचल प्रदेश. गुवाहाटी. असम नागालैंड मिजोरम एंड अरुणाचल प्रदेश. 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 Assam, Nagaland, Mizoram, and Arunachal Pradesh. Contribute